Good morning to all those present at today's public hearing of the Vetting Commission established under Law number 65/2023 on the external evaluation of judges and candidates for the position of Judge of the Supreme Court of Justice. My name is Andrei Bivol. I'm the president, the chairman of the A panel of the Commission, and I declare this session open. This hearing is being conducted under the evaluation process based on Law 252/2023 on the external evaluation of judges and amendments and prosecutors and amendments of some regulatory acts. The subject of today's hearing is Cojocaru Olga, judge at the Central Court of Appeal, previously the Chișinău Court of Appeal. Hello and welcome. Thank you. Hello. I have two other members of the A panel. On my right is Lilian Enciu, the national member, and on my right, Madam Perling, international member. In the room, you have representatives of the media and the public. Also, in the room, we have a photographer who will take pictures in the opening of the session for several minutes. The hearing will take place in Romanian and English in order to ensure accurate interpretation. Please speak clearly. The hearings are recorded. Generally, the recordings of the hearing are available within 3 days after the hearing. The deliberations will not be published, but they will be recorded and attached to the report. During the hearing, one or two other members of the panel will ask questions. Please answer these questions clearly and briefly. Your explanations are important to assess your ethical and financial integrity. At the end of the hearing, you'll be able to make a final declaration. We'll take into account your private life, your privacy, and the privacy of your family members and your close people. This is why we'll not mention ID numbers, bank ID numbers, exact addresses of real estate. And in order to protect your privacy, please do the same. Next, I will refer to the evaluation procedure. The Commission started the evaluation of Olga Cojocaru on 11th of April 2024 by sending a notification via email and asking to fill in an ethics questionnaire and declarations provided for in Law 252/2023. Cojocaru Olga returned the declarations and the filled-in questionnaire on 30th of April 2024. As part of the ethical and financial integrity of a subject, the Commission obtains information from other sources such as the National Integrity Authority, the Tax Service, the General Inspectorate of Border Police, other public institutions, financial institutions, and open sources. On 29 October 2024, the Commission requested for Olga Cojocaru to provide additional information by 10th of November 2024 in order to clarify certain aspects. The subject provided answers on 10th of November 2024. On 2nd of December 2024, the Commission requested Judge Olga Cojocaru to provide additional information by 12 of December 2024 in order to clarify other aspects. The subject responded within due time and provided the documents by 12 of December 2024. On 23rd of December 2024, the Commission requested Judge Cojocaru to provide additional information by 2nd of January 2025 in order to clarify certain aspects. The subject provided answers within due time. On 24th of January 2025, the Commission informed Judge Cojocaru about the doubts identified and that shall be discussed in terms of compliance with ethical and financial criteria. Also then, the Commission invited Judge Cojocaru to participate in today's hearing. On 27th of January 2025, Judge Cojocaru sent the Commission the request for the hearing to be a closed one. On 30th of January 2025, the Commission sent the decision to accept this request. On 2nd of February 2025, Judge Cojocaru sent the Commission additional explanations regarding doubts that will be raised within the hearings. Beside this, on 2nd of February 2025, Judge Cojocaru sent to the Commission 2 additional documents. Bank statement of transfers made by an associate first, and a second bank statement of transfers made by the same person, certificate from the Supreme Court of Justice on the income obtained by the spouse, and the declaration signed by the mother of the subject. Madam Cojocaru, do you want to correct or add something to the answers that you provided to the Commission previously? No. The answers in the ethics questionnaire and declarations that you returned to the Commission on 30th of April 2024 are still valid, with some rectifications. Members of the panel will ask additional questions on the doubts identified. We'll try to make sure that our questions are short and on the point. We ask for your answers to be short and on the point. We'll start with the doubts that will be examined in a public hearing, and in the final part we'll discuss the aspects that we decided to discuss in a closed hearing. We'll start with financial integrity aspects. We'll discuss about a Renault vehicle that was sold by your mother, according to your declaration. We're speaking about 2021. From the notification on doubts. So, can you present supporting documents that will prove that the real selling price was 4,000 euros and not 10,000 lei, as mentioned in the contract? Mr. Chairman, regarding this vehicle, Renault, I explained this previously, and I can explain you again in detail about the situation with this car. This car was bought in 2018 by my mother. There was an agreement between grandparents to buy a car for the grandchild who turned 18. When the grandchild grew out of that car and decided that it no longer satisfied his needs, he decided to sell this Renault vehicle together with his mother. If it was sold with the price, if it would have been sold with the price, the real price, it wouldn't have been possible for him. We just presented this declaration stating that the grandmother bought a Volkswagen Jetta, the car of the grandfather, and then added some more money and bought this car, Renault. Why did you indicate 10,000 lei? Mr. Chairman, I did not participate in the drafting of the contract, and I don't know why it's this amount of 10,000 lei in the contract. Tataru Lyubov was part of the contract. She told me that this was an agreement with the seller. Did we understand correctly that due to the relationship grandmother-grandson, this transfer of these 4,000 euros were not formalized? Regretfully, yes, I just presented you with the declaration. She's an old woman. She acted how she knew best. The same year, according to the information provided by you, your son would have received, it's about 21, yes, of 45,000 and 55,000 lei from his grandmother and his father. I understand that these donations have not been formalized in any manner. Mr. Chairman, in the explanations presented to you, I tried to explain how these donations were made. Do you mean the explanations sent yesterday? No. On 2nd of February, yes. In my explanations, I tried to show how these transfers were made. First of all, I explained to the Commission that the financial capacity of my husband and his mother were put into question. And I want to tell you that the bank statement, there is a bank statement showing that during the pandemic, because it happened during the pandemic, 2020-2021, Judge Cojocaru, the father of my son, received several transfers from another person living in Tiraspol, Vechaev Yuri, and from the grandmother, Ludmila Cojocaru. This amount was $8,100 US. So the financial capacity of the former husband and grandmother is confirmed. They had money. The problem is, I don't speak to my former husband, but the Commission talked to him, and he said that we don't communicate anymore. And if we're speaking about year 2021, I want to explain to you that once I started a new family, my husband, my ex-husband, became even colder to me. He didn't want to speak to me anymore. Let's speak about the leasing installment payments for the Skoda vehicle. and it's also for year 2021. In your declarations, you informed the Commission that all the leasing installment payments for Skoda Superb bought by your son have been paid by himself from his own income. The question is the following. How do you explain the fact that your son's income of that year was 63,000 lei, and out of which 43,000 lei has been spent on expenditure, on basic expenditures? But the leasing payments would have been 74,000 lei. How do you explain this? I will explain it. If we look at year 2021, he was 21 back then. He had some attempts to grow, develop, and buy a more expensive car. This Skoda car is from 2018. So regarding these 74,000 lei, I want to communicate to the Commission that he used his own money. If we look at the table, there are 4,000 euros from the selling of Renault car, which is around 80,000 lei, plus the help provided by Mr. Cojocaru and his grandmother, the financial help. And back then, he was young, he wanted to show himself, to buy a more expensive car, and in the end, my partner helped him. But don't forget, there's this financial help from the grandmother, from my partner, and from selling the Renault car. What was the financial support provided by your partner? If you make the calculations, it's if you deduct the amount remaining from the total amount of the selling of the previous car and the support provided by his grandmother, you will have the amount. And he also worked for a time in Greece. Could you please explain why you did not mention all the donations used to cover these leasing installments in the first round of questions? Because this question was asked, or some information was provided in the first round of questions, and other information was provided in the third round of questions. Mr. Chairman, I will reiterate my position. The contract concluded by my son was a leasing contract. But he said, look, Mom, I will take over some responsibility and I will be able to cover the cost. So there were questions arising from the Commission, so I asked him these questions as well, and it took some time for him to answer these questions. So you say that you didn't know about this. Honestly speaking, he worked unofficially in some places. He would go to France to work. And sometimes, indeed, he worked unofficially for bailiffs sometimes. So your answer is that when you answered the first round of questions, you didn't know, you didn't have this information. When this car was bought in leasing installments, I asked him, how will you cover the costs? And he said, I will do my best to cover the costs. In the end, he wasn't able to do that and sold it. He understood that a leasing contract is not something that he can afford. Okay, let's move on to 2022. And let's speak about the purchase of a BMW X5. On 21st of January 2022, your son bought a car, BMW X5, made in 2014 for a contractual price of 290,000 lei. The technical inspection in June 2022 showed that it had 132,025 kilometers on board and did not have significant technical deficiencies. Can you explain how this price was established as the real price of the vehicle? Mr. Chairman, my son was looking to buy a car. The car that was made in 2014 and he bought, so he understood that he should buy an older car, not from 2018 but from 2014. And this price, 290,000 lei, was from the Skoda Superb contract. It was bought from a legal entity. There's fiscal receipt according to law on entrepreneurship. And you can look at the receipt as well. The receipt is the primary document here. Regarding the doubts of the Commission relating to the price, after looking at the materials collected by the Commission, I established some other circumstances as well. This car, BMW from 2014, it was bought in 2022 by my son, but in 2020 there was a contract concluded between City Arena and another person, and according to that contract, the price of that car was 290,000 lei. I learned about this contract on 30th of January when the materials of the evaluation were brought to my attention. To conclude, in the situation where on 10th of January 2020, the BMW X5 was sold for the price of 290,000 lei, it is obvious that on 21st of January 2022, namely after 2 years, this car could have not have the price indicated by the Commission. Thank you.
How could you explain that the average price of import established by the customs service for the vehicles of this type or of this make or identical vehicles is for 438,000 euros, not a less amount of money? Mr. Chairman, I have already explained in our session, I'm not a specialist in this domain. He's very passionate about vehicles and actually he's been passionate about since his childhood. It's very specific for a male, in fact. I have explained to the Commission, I'm a judge. I've been presented with documentation. I saw the invoice and I was explained these details. I only talk about things I see. I base my conclusions on the invoice. If the real price of the car was indeed 290,000 lei, what was the reason of your son trying to sell this car for 33,000 euro? Once again, he was very young. He's very passionate about vehicles. He saw that there is an opportunity, but however, his attempt failed. That BMW from 2014 wasn't so presentable as it is thought. And now you're trying to say that your son, being passionate about vehicles, actually put a price tag on it which was much higher. Well, actually, he thought that he's going to earn some money out of it. The amount that he indicated, the price tag put on this car, has not materialized. You can put a price tag on everything you want in the Republic of Moldova. However, it's not the case that you'll be always successful. Could you please tell us that the amount paid for this BMW was paid in cash? Yeah, that happened following the selling of the Skoda. Is our interpretation correct that the amount paid for that vehicle was paid in cash? As I explained, he went to that company, he paid the money, they provided him, they issued him an invoice. So he took money from the person to whom he sold the car, and then he used that money to pay for the new car. I already explained about these issues in my documentation. Now let's go to 2023. And here let's talk about some transactions with vehicles. On 30 May 2023, your son bought a car, a Mercedes-Benz make E-Class, manufactured in 2017, for a contractual price of 250,000 lei. And now we have a situation here, a similar situation, but it's actually more nuanced. The contractual price of 250,000 lei, our question is, how could you explain the fact that the same vehicle has been imported into the country with a value, custom value of 415,000 lei? First of all, I would like to draw your attention when that vehicle was introduced in the country and when the vehicle was bought. Second of all, when it comes to the Mercedes, I explained to the Commission, when he bought this vehicle, he understood, he realized, he tried to actually to earn some money, but he understood that the year 2014 was quite old, and therefore he thought that he is not going to be successful in selling this vehicle for good money. Therefore, he reached out to a company selling vehicle on the local market, and he actually exchanged the vehicle. He swapped the vehicles. He gave the BMW, taking instead a Mercedes. Following the questions formulated by the commissions, I was very curious to see and understand how this scheme works, and I really understood that in the Republic of Moldova, the companies selling vehicles, they accept this type of deals. They receive the vehicle you used to have, and they provide you another vehicle instead, in exchange. I would like to explain that the objections of the commissions with regard to the fact that transactions could not be carried out in cash I disagree actually to that, since these sort of transactions pertaining vehicles have been conducted and carried out between individuals, not companies, and the law does not limit transactions carried out in cash by legal persons. The person owning Dream Auto parking lot in this transaction has not had the quality of seller or buyer. However, it played the role of an intermediary who was not empowered to receive or to make payments on behalf of Andrei Cojocaru. Madam Cojocaru, I will repeat my question again. My question, of course, we will talk about it later, about the type of transaction chosen by the sides. And if there was a exchange between the cars, why wasn't a contract? But my question is, what is your explanation between the huge difference in the amount for this vehicle? Vehicle was introduced in the country, and at the customs it had a value of over 400,000. In the contract we have only 200,000 values. On the second market, the market price for this type of car is about 100,000 lei. How would you explain this diminished price? Because the vehicle did not have any deficiency. It had a very good mileage, over 100,000 kilometers. So what is the explanation? Maybe your son told you why he diminished this price in the contract compared to the real prices. I tried to explain why the price. I asked him expressly why he put this price tag, and he explained if we go on car vertical and verify this car, and I actually presented to the Commission the documentation attesting that this vehicle, and I'm not sure what were the reasons of this car entering the country in such a way, but car vertical actually showed that this very vehicle had very serious technical issues. Let's talk a little bit about the car vertical report. The car of your son's car was produced in 2017. Could you please explain why in the report that you submitted from car vertical you indicated a car originating from 2016 actually? I explained that he introduced the VIN. It's a code which you actually use this code in order to double check on any vehicle in car vertical. In fact, that car was in fact from 2016. So what you're implying here is that it was produced from 2016. I'm not sure why he presented it as being manufactured earlier. I'm not a specialist in this field, honestly. People involved in this sort of transactions are much more familiar with that. I'm not. Let's now discuss about transactions a little bit. You mentioned that there was an exchange between individuals which was brokered by a legal company. Why wasn't there a contract? Mr. Chairperson, dear members, the contract with regard to exchange of the cars could be established or signed between two persons who make a swap. A switch, actually. And the right to ownership is very specific. So the signing of a contract was impossible because the vehicle, the BMW vehicle, has been sold on 20 March 2023, and Mercedes was given to him on 30 May 2023. He left the car at that parking lot. Please find me another car which is better. And this actually explains the reasons why they exchange these cars between them. But I'm telling you once again, the owners of this parking lot, not only Dream Auto, but the majority of these legal companies, they actually are heavily involved in this sort of dealings. So these sale and purchase transactions have been carried in cash. Mr. Chairperson, I would explain. He didn't pay any money. It was a exchange of cars. He left his personal car and he received another car instead from another seller. And the price for this type of cars are different, right? So BMW was sold for 280,000, the Mercedes was bought for 250,000. So it was an agreement between these sides. This is the agreement between them. But in fact, it was an exchange. And there is no difference between prices of these cars. So from what I gathered, I left the BMW and I received the Mercedes. This is what my son told me. Now let's discuss some of the aspects related to ethical integrity. In the notification for the meeting, for this hearing, we communicated the decisions of the European Court of Justice issued in the cases where you took part as a judge. And we retained two cases, Produce and Hochlov against Moldova. Both cases actually have not been fairly attributed to your clients. Given the similarity of these two cases, the Commission have examined both of them together and have found that in the case of Produce and others, which refers to four connected cases, Totovic, Darius, you participated in two of them actually as a judge, in the first instance in case Kotovic, and as an appeal court in Nika case. In case of Kokhlov and others, we've had three cases, Kokhlov, Starish and Kistol. You took part as a judge, as a Chișinău judge with regard to the plaintiff Starish. So in these national procedures where you took part, the plaintiffs under the Law 27 have been admitted partially, being recognized as an infringement with regard to the enforceability of the provisions, and people were asked to actually pay damages for that. The amounts, the compensation actually paid for the plaintiffs as a moral damage were set at 2,000 lei and 5,000 lei and 22,000 lei for an enforceable period of 2 years and 1 month. In the case of Nika, this amount wasn't reasonable, which is reported to the European Court of Human Rights. And the quantums established in the recommendations of European Court of Human Rights, respectively, the case was not examined by the judges. In the round of discussions, you responded by the 2,000 lei in Kotovic case and 5,000 in the situation of Staric represent a reasonable price and a correct one with regard to moral damages. When we are talking about the judicial practices, you also declare that you admit that the amount paid as damages were significantly lower than those recommended by European Court of Human Rights. At the moment of examining this case, we had a case law, a very rigorous case law of the European Court of Human Rights with regard to reasonable period of damage payment with regard to Crista, Botezato, and we also have information that in some cases CEDO actually set out 3,000 lei as a damage for not enforcing this sort of payment in time. My question, the main question, what is the reason why you have not used the case law of European Court of Human Rights when it comes to a reasonable period when paying this sort of payments to the people in question? I totally support what you mentioned so far. But I would also like to add that I also took into account the recommendations. The recommendation does not have has a consultative character. At the same time, when those amounts have been established, I also took into account the national practice. I would like to communicate that in the first case and in the second case, both solutions have been maintained by the Supreme Court of Justice. Therefore, taking into account that the recommendation of the Supreme Court of Justice actually qualified this as a correct decision, I believe I don't believe that there should be any doubts with regard to myself. The amounts set out were provided during that time based on prior to that, it was an amount set out for this reason. And I considered that those amounts were based on the livelihood of people in this country. And once the Supreme Court of Justice has maintained this decision, has supported this decision, I don't think I took a wrong decision, so to say. How would you explain this discrepancy, huge discrepancy, in the case? In the Starish case, you disposed actually a moral compensation for 5,000 lei in an enforceable period of 2 years and 5 months, and in Nika case, you disposed 22,000 in an enforceable period of 2 years and 1 month, which is a shorter period of time, but a compensation which 4 times higher. Dear members, the law 87, and we also had the recommendations. So based on these solutions, irrevocable solutions of the Supreme Court of Justice, we took into account these amounts when establishing them. So I gather that for you as a judge, you had at your disposal 2 sources, guiding sources. One of them was the recommendation of the Supreme Court of Justice, approved by the governmental agency, establishing some minimum quantums for infringement, some minor infringement there. And in addition to that, there was another practice of the Supreme Court of Justice, who was also contrary to the same recommendation. And you, as a judge, considered that the precedents on these cases have a greater value than the general recommendation. So my obligations, my duty in examining these cases, and I would like to reiterate, is not based on recommendations. It's based on the Article 120, 132 from the Civil Procedure Code. Thank you. Up next, let's discuss about the lack of... You have not declared something with regard to your declaration of assets and interests. The Commission has identified 8 cases of not presenting information with regard to the income and information which could be considered as a violation with regard to the assets and interests. However, we will discuss only 2 of them because only 2 of them are actually part of the 5-year framework provided by the law. The first one refers to the abstaining to declaring to National Integrity Agency of very important information. You mentioned that you received some type of income in 2018. How could you justify that you have not declared to this income to National Integrity Agency? I recognize, I admit that I have not declared, but I have not done that intentionally because the alimony and those for those amounts there was a legal decision. So I actually started my relationship with the current husband, and we've had some questions. I admit that I have not declared those amounts indeed. So what was the logic not to present this information? I wasn't interested in that. You informed us about that. My question is why you have not introduced this income in the annual declaration of income and assets. It was an omission on my part, I admit that. But again, it was the alimony. At the same time, you actually omitted some information with regard to income of your concubine in the period of 2022-2023. We are talking about some salary payments obtained from a limited liability company. In the first round of questions, you said that you are not aware about these sort of incomes received by your concubine, and therefore you found out about that from us. You learned about these incomes from us. Later on, you emphasized that those payments were actually received by the parents of your concubine as a recompensation for the lease of some agricultural plots registered on the name of your concubine, but which are administered by his parents.
Mr. Chairman and dear members of the Commission, in order to clarify this situation, first of all, I'd like to mention that he's not an employee at Popesteanka LLC, but at Chișinău Gas. And this land plot has been rented for a long amount of time. This is the usual practice in rural areas. And they were given crops instead for renting that land plot. So I cannot see that I received these 4,000 lei every time. But yes, there were some crops, some grains that were received resulting the renting of that land plot.
plătește veniturile, că îi plătesc salariul.
Yes, but he declared that he received
Pentru că informația asta
he
vine de la
receives a
fisc,
salary.
nu
This information
am
is from the
identificat-o comisia.
State Tax Authority. This is not something invented by the Commission. I told you, he cannot be an employee at Popesteanka LLC. He is an employee at Chișinău Gas Company. It means that this income could be perceived as payment for rent. To be honest, I don't have details. I know that these land plots were passed on to him from his parents. A part of the land plots have been donated to his sister. I did not get involved in these matters. And for me, it was not morally correct to go and ask money from that LLC or from renting. Now I'd like to ask you about buying the vehicle Peugeot 208. Bought in 2022. No, it was bought in 2020. The contractual price of this vehicle is 20,000 lei. How did you reach this price? How was this price established? In the situation where the import value of this car was 96,000 lei. From what I've observed back then, during the pandemic, this car was bought from the sources of my cohabitant before we got together. He bought the car. He was a driver for his whole time. He worked as a driver in the Czech Republic for 20 years. So he had some connections. He found this car. The car indeed was undervalued, but I was not party to that contract. So I don't know what to explain to you if this vehicle was bought from his own resources. It was bought in May from his own resources, from his own money gained in Greece. He sold his house in Drochia district. So he had financial means. Thank you. The public hearing matters have been fully discussed. Dear colleagues, members of the panel, do you have any questions?
I have some clarifying questions. About your son and about the cars related with him. So, first of all, could you please tell us where did your son live in 2021, 2022, 2023? I don't ask address, I just ask with you separately, or...
He was living with me.
Thank you. And what was your son doing at that time? You described that he worked unofficially, but full-time, part-time, he also studied.
Dear member of the Commission, I'd like to clarify something here. My son was studying at this law school, but without going to courses, and he was working at the same time. So he was studying and working at the same time.
And when we talk about the cars related with him, Renault, BMW, and Mercedes, who, or I ask that, As I understand, he used the car, yes? But what about you? Did you also, as a mother, use the cars?
Nu.
No.
Eu am explicat comisiei
I explained to the Commission
rundele de întrebări
in the
că într-o
question
situație
rounds,
de jusor,
in a
când el a încercat să
situation,
fac față
he tried
acestui automobil, dar până la urmă el a văzut că
to pay for that car,
nu mai poate, l-a vândut.
but he was not able, and I acted as his personal guarantor in that situation.
Yes, exactly. It was my last question. You described how he bought the cars, it was his passion, but who took care about the cars? Full, it was necessary to pay for repairs. How it was organized, because he studied, he worked partially, but still. Cars don't need only money for what to buy them, but to care about them.
Am explicat comisiei ce ține
I explained to the Commission
astea Școda.
regarding Škoda car. I participated in his payment for the casco assurance, and he tried to juggle everything. When he had money, he would drive the car. When not, he wouldn't. About repair works, he did not have to have repair works. The Škoda car was manufactured in 2018, so that car did not need maintenance. The BMW was sold. This was the purpose, to gain some money from selling that car. Subsequently, between 2022 and 2023, he went to France. He worked there for 5 months. He had a salary of 800 euros. After that, he went to Nice, also in France, and he had there a salary of 2,000 euros per month. He was aware that he needed to have financial means and sustain himself. And he worked abroad because he wanted to have more money. And I presented all the statements of his from when he worked in France.
And my very last question. Could you please repeat one more time what you knew about the changing of a manufacturing year of a car?
A card vertical?
Yeah.
Anul 2016, da? El înainte
In 2016, before changing that car, he wanted to know what was the fate of that car, what was about this car. He knew about this app where you can verify a lot of details, and you introduce the code of the car, and you can see where that car was manufactured and other details. In Car Vertical, he saw that that car was manufactured actually in 2016, not in 2017, and he would negotiate the price due to the fact that he was able to use that app. Before making that exchange, he learned that the car was manufactured in 2016. And he doesn't have the power to change the year of manufacturing because there are some official documents.
But did he ask advice from you, because you are judge, you are his mother, because this is serious topic, change manufactured year?
No,
No, okay.
nu
No, he never requested any piece of advice from me, and this is the problem actually. I will explain to you. My son was always a leader type. He played handball, he was a team player, and he learned to work hard. And my opinion was never very important. As a mother, I did my duties, clothing and feeding him, but after 18 years of age, I did not get involved in his
No more
education.
questions from my side.
În continuare vom discuta dubiile pentru care au fost
Next,
identificate
we'll
de
discuss
ședința
the
închisă,
doubts
cu
in
excepția
the
personalului tehnic
close-
asigură registrarea și
in the closed hearing.
lucrătorilor, rog toată lumea
Besides
să
the
sală.
technical staff and interpreters, I'd like to ask everyone to leave the room.
Doamnă judecător Cojocaru, Comisia a epuizat
Madam Judge, the Commission has
față
finished
de dumneavoastră.
its question for today.
La sfârșit, dacă doriți,
In the end, if you would like to have a brief statement before closing the hearing.
Stimați membri ai Comisiei, eu vă mulțumesc pentru...
Dear members of the Commission, I would like to thank you for taking the time to hear my declarations.
Noi suntem oameni și
We are all human beings and we sometimes can do wrong things. I do admit,
am recunoscut. Da,
I admitted my wrongdoings when it was the case,
din timp ulterior.
but that is actually apparent only in time.
Asta e tot.
This is all.
vă
Thank you.
mulțumim. Am ajuns la sfârșitul acestei
Thank
audieri.
you. We have now reached the end of today's hearing. I would like to thank you for participating in this hearing. The Commission will issue an evaluation decisions regarding whether the candidate meets the ethical and financial integrity criteria stipulated by law number
Raportul de
25,
evaluare va fi întocmit
and
probabil
the
cât de curând posibil.
evaluation report will
Mulțumesc
be
pentru această
issued
prezență.
as soon as we can. Thank you. We now declare this hearing closed.